Hello everyone. This is Specific Relief Act Part 2. This is Part 2. In the last video itself, we had covered the overview of Specific Relief Act. I had told you what all reliefs are available to you under Specific Relief Act. We had talked about the nature of this act. We had talked about that it is, and we had talked about the savings clause as well. If you not watched that video, please go to that video first. It's in the playlist. You can open my channel and see on the playlist of Specific Relief Act that video before going for this video, because hereby I'm continuing from that particular aspect itself. Alright, okay, let's start with the last, in last class itself I had given you an example of James. I had given you an example in this case about he's King James, he's living in his palace, he's happy. Suddenly these two people come. These two are the trespassers. These two come and then they tell that no, now they basically evict this king. They basically want कि एक king को बोल देते कि तुम भाग जाओ, अभी this palace is ours. So what should the king do? That is a question which comes to everyone's mind. To answer this question, we will be talking about section 5 and 6 of SRA, which is specifically talking about the immovable property. This section 5 of Specific Relief Act, this provides us the remedy in terms of this section is not creating any new right. It is basically affirming what you already possess, your pre-existing right. Why I say so? That's why it is called as a declaratory provision. If you understand section 5 from the example which I had given you, in this case, what the king has the title over this land. Alright, so here under section 5, what the king wants, king says that he has title over this property, and these two people do not have the title over the property, and now king wants the court to declare that he is the legal owner, he possesses it. So what he will do, he can file under section 5 suit under Specific Relief Act. This section of section 5, why it is so important, it's not creating any new right. Alright, it's not providing any such relief. It's not providing any relief. Here what it is directing you to the Civil Procedure Code of 1908 under section 9. What the section 9 says, if you have studied the CPC then it's good, if you're not then it's also fine. Under section 9, it allows the court to try any civil dispute. Here this dispute is about the ownership, because he has been evicted from this particular land. So you understood that this is basically the whole procedural aspect of CPC. CPC is the Civil Procedure Code. If you don't know, I'm just giving a brief gist as to Civil Procedure Code has a proper procedure. If you understand CPC versus reliefs under SRA Specific Relief Act. CPC follow proper procedure as to how the plaint will be filed, how the evidences will be collected, how the issues will be framed, trial process goes on. So a lot of things. If you have read the CPC then it's fine, not read then also you can understand this. This is civil procedure. Then SRA, it is a summary trial kind of thing. Summary trial, it's like a brief trial. This is the major central aim of this. This is to provide relief. So it is quick. The nature is quick and speedy. Under section 5, if you see, the major question which is dealt by the court is the title. Title is dealt by the court. Whoever has the better title over another one, that person wins. Here title is of the most under section 5. If you see section 5 of SRA, title is most important. This title can be based upon ownership, and also be based upon the possessory title. Possessory title, what it means, possessory title is, possession means this king can tell to the court that I have been in the possession of this property for like 15 years. 15 years of, here it's like long peaceful possession. Alright, so here king can show that he has been staying here for 15 years and it was a peaceful possession as well. So the person with the best title should win. Ownership basically mean I have proper sale deed of it. I can prove title in the court of law. That is something you need to prove. That is the whole scenario about section 5, the major aspects of it. Now understand, therefore, if party is in the peaceful possession of land and is disposed of it by another with a title no better than his. In this case, if king can show that he has been in possession for 15 years and these two people have just came now, what the court will see? Court will use the provision of possessory title. Court will say that king has been in possession for like 15 years and that's why king has a better title in this case. So this is basically declaratory, as I told you, declaratory. It's not giving you any new kind of right as such, not relief it's not giving. It is just redirecting you to CPC. That follow your CPC. CPC is a general law. The Specific Relief Act is a substantive law. Substantive law because it's creating some rights. You can deal with the cases like Naba Kishore Tilak Das vs. Pura Beva, where neither the plaintiff nor the defendant was able to prove the title, but the plaintiff was able to prove his possession for 4 years until he was dispossessed. The plaintiff was entitled to the degree of possession since he had a better title, possessory title, than the defendant. This case dealt into the fact that neither of the parties were able to prove that they have the title. But plaintiff could prove that he was in possession for 4 years. So since the title, the one who is owner, is under dispute, but the possession is also given a lot of consideration. Possession को बहुत important माना जाता है. अगर उसके पास 4 सालों से उसका possession है, this means that कि plaintiff का title is much better than the defendant का title. तो उसको possession, तो degree of possession जो है, it will be passed based on the possessory title. Even the owner of the property can get back possession only by resorting to the process established by the law. What these case laws are telling us? This case law is also telling us about the owner of the property. That even the owner of the property cannot resort to any sort of violence. They need to resort to the proper process. If you see this example, this is the owner and this is a tenant. Tenant has not been able to pay the rent, and because of that, owner has sent the eviction notice to tenant. This eviction notice is sent to tenant. All right, but tenant is still refusing to vacate that place. So can the owner be allowed to resort to violence? Can owner in this case, क्या owner को बोल सकते हैं कि तुम गुंडे ले आओ, anything of such sort? Will he be allowed to follow such kind of means? There is requirement always to follow due process of law. What is due process of law? If the owner now in this case wants to tenant to vacate this land and tenant is not ready to do this because owner here in this case has a better title, has a title over this land. All right. So what the law wants under SRA, what the law wants the owner to file the civil suit. Civil suit will be required to fight under SRA. We know the section 5 because it's based upon the title. This completes our section 5. Section 5 is a very easy section provision as well. I explained you in a proper way. We have covered the case laws as well. Let's move on to section 6. Now let's move on to section 6 through an example. Move on to the same example as I took for section 5, but now the facts of the case here in this case are, इस केस में क्या होता है, लेट्स अंडरस्टैंड. जो किंग है, किंग इन दिस केस, वो पीसफुली ही वाज वॉकिंग इन हिज गार्डन, ही इज़ वॉकिंग पीसफुली इन हिज गार्डन, ठीक है, एंड ही इज़ इन अ सेटल्ड पोजेशन. He is in a settled possession. We don't know whether he had title or not. Probably वो king का जगह नहीं है. So but he is happy. And these armored people, this armored man, he pushes king out. He's like, these two people come pushing king out. And what it is, now they are doing forceful dispossession. Here the most important word is forceful dispossession. You understand the word forceful dispossession. Here dispossession is the major word. Dispossession means you're disposed. Hereby dispossession means कि तुम्हारी जगह थी वो, अभी तुम्हें उससे निकाल दिया. You are evicted out of this place. And this man comes with this fake deed and he's justifying their possession, and they are not following the due process. क्या follow कर रहे हैं ये लोग? Muscle power plus fake deed. This is what they are following. तो इस केस में what all ingredients are getting fulfilled? The first ingredient is king was in possession of immovable property. He was in possession of immovable property. That was the major ingredient of it. And he was dispossessed. Second is dispossession without consent. Without his consent. And this dispossession which is happening, it is dispossession not with due course of law. There is no due course of law which they have followed. And then fourth one is, this king now goes to court within 6 months of dispossession. King now goes to court. ठीक है, dispossession होने के within 6 months he has to go to court. Within 6 months. If all these ingredients are getting fulfilled, then it is a case which can be filed under section 6 of SRA, which is a specific relief remedy. Let's go on to the provisions to understand it better. Section 5 of this act, applicable when plaintiff was in juridical possession of the immovable property. Juridical possession. First, understand juridical possession in detail. Juridical possession basically means, for section 6, it's prerequisite for you to have juridical possession. Juridical possession basically means a possession which law recognizes. Possession which law recognizes and protects. Even if title is imperfect. What I meant to say by all of this, probably this person, this house, alright, in this house, if I'm a person, I don't have the title over this person, but law recognizes my possession. What could be those scenarios in which law is recognizes? First could be owner in possession. Owner in possession, we understand owner in possession. That person, obviously, owner in possession, that ownership also, that person has possession is there. But apart from that, the scenario can be tenant. Tenant is basically, I've paid the rent, and for that particular period, the law recognizes that I will have the possession over this land. There can be licensee. I've got the license. I've paid the amount and I've got the license. Or there is any scenario, any person in settled peaceful possession. Peaceful possession is also recognized by the court, even though you do not have the title, but you have been staying in this particular house for a long period of time and there was no dispute. Suddenly after 10 years, nobody can come and evict you. Here in this case, as I took the example, in this case, king has been staying here for the period of 12 years, as I took the example. Now, should these two people be allowed to come and challenge this And should that person be allowed to, these two be allowed to claim the, even though this deed is not fake, this is proper, but the kind of mechanism they have used, what they are using, they are using muscle power, they are possessing a person. The law recognizes the basic purpose. Law का purpose क्या है? To help those people who are disadvantaged, the one who are facing the hardship. एक बार में सीधा उसका dispossession अगर हुआ तो it is causing hardship to that person only. Alright, you understand that? Firstly, as I told you, the prerequisites must be in possession immediately before the dispossession. To file a suit under Section 6 of SRA, there is a requirement that the person who is claiming that he must be in immediate possession immediately before the dispossession. Here in this case, I told you, King was in possession of that property before dispossession happened. Just imagine in this particular case, if King had stopped staying here for like 2 years, and after this 2 years, and King now came to this palace, and now these two people are challenging it, then you cannot file the suit under Section 6. The major purpose of Section 6 is to protect the immediate possession. Immediately, then if that kind of case, then you follow your procedure under civil procedure. But here the law's purpose is कि specific remedy is person को provide करना. That is the main purpose. Let's move on to the cases which are important to understand this. Plaintiff was a rightful owner but was wrongfully dispossessed. Then you can file because he was a rightful owner but he has been wrongfully dispossessed. Here the case is on the basis of possession, as I told you. But in the Section 5, the major comparative was, as we dealt in Section 5, Section 5 is based upon title. Section 6 is based upon possession. That is a major point of difference you need to know while you are filing any suit. K.K. Verma Union of India, even after the tenancy agreement was terminated, the tenant still has the right to hold juridical possession. Juridical possession, as we discussed only, he could only be dispossessed until the owner got an order of eviction against the tenant. These 2-3 cases, this case as well as the case of Narbada Devi Gupta versus Virendra Kumar Jaiswal also, these are basically based upon the concept of the dispossession happened without consent and also otherwise done in the course of law. Just imagine the scenario in this owner and the tenant, as I already given you this example. Here by owner has already given the eviction notice to tenant. Will it be sufficient to end the juridical possession of tenant? Is it? No, because here now owner cannot be allowed to use force against the tenant. What the owner can do, owner can get a notice from court. What is otherwise then in due process law? Agar this dispossession is happening without any court decree, without any lawful eviction process, and there is no statutorily कोई statute, कोई case, कोई court ने नहीं दिया, till then tenant will hold the juridical possession. This means that eviction notice is not enough. Proper following of court process is important. Notice of eviction from the court, proper court decree is required. Till then, tenant will hold the juridical possession of that particular land. These cases are basically talking about the same thing. Then you have this case also. The major aspects of these cases are same. The long-standing peaceful possession is sufficient proof. If a person has been staying for a long time at that particular, as I gave you the example of that king, he was staying there for the long period of time, and it was undisputed possession. You require for this, there should be undisputed possession. It is a good evidence. It is a good evidence of juridical possession. For this, plaintiff in this case, जो long standing जो claim कर रहा है कि I was staying here for the long time, that person don't need to prove the title. Possession itself is a evidence. Possession itself is proving that. Let's move on to the next case of us in K. Krishna versus A.N. Paramkushabai. The tenant was unlawfully dispossessed, but instead of resorting to lawful means, he used force. Then he became a trespasser, plus suit under SRA was filed 3 years later. This case is just giving a reverse of what we have told about. The same scenario, the same facts are similar in this same facts, but what happened in this case is this tenant was dispossessed. As we had used this example earlier as well, this tenant was dispossessed, and but he filed a suit under SRA under section 6 after 3 years. But what is the requirement? The requirement is within 6 months you need to file the suit, because the purpose of section 6, you need to keep on understanding and remembering the purpose why we have section 6. Section 6 is for the summary trial, so that you can provide the immediate remedy. After 3 years you are filing the suit, then that suit cannot be filed under SRE. In this case, disposition took place not 6 months from the date of filing of suit. Before this is a 6 month period. It's like I call it a window. This is a window period which is provided. Within this month itself you need to file the case. Dispossession should happen immediately before this period of time. Here the time has passed 3 years. So this is a reverse way of saying that disposition took place not 6 months from the date of filing. From the date of filing itself, it did not take place 6 months. 6 months is the maximum amount of period you have. You can file immediately as well, and or within 6 months. Suits after 6 months has no meaning. This Subrata Kumar Das versus case has given us understanding that if you're filing any suit after 6 months, it will have no meaning. You can go to court. One thing you need to understand is you can go to court, but it will be under regular civil suit. In this case, what can happen? Here he can file the case as to under for title as well, for possessory title. Tenant can file the case. What else tenant can do? Tenant can challenge the process which was used. So the other alternative remedies are also provided under various other legislations. You can use it. You do not need understanding of that right now, but you need to know that. Alright, so one thing now, the next important pointer of this whole chapter is about that you cannot file under section 6 the cases against government. Why you can't? Why should the question should come to your mind that why this whole this isn't it unfair that against government you cannot file? But you need to understand this law is giving the protection to the government, the suits against government, because government is one of the biggest litigator. Whatever cases you hear, always you see state of Union of India is always in news. Union of India, there are a lot of litigator. A lot of cases are only filed against government itself. So here you need to follow the normal procedure. What is meant by normal procedure is civil procedure. Means you cannot file for the speedy remedy. This right of section 6 is only available against private individuals. You cannot file against government. Why this right is an important answer of it is 6 month period is given, because in this particular case you are given only 6 months to file the case. What it would cause if you will be given the opportunity to file against government within 6 months itself, you will obviously take the recourse of specific relief act, because obviously you will take the this only. But what it would do, this can cause this can stop the equitable remedy in the equitable remedy can be like government in itself has commissioners, government in itself has departments. Equitable remedy can be administrative remedies. Just suppose that this your land has been taken because government is building some bridge, or there is because of some other act, there was requirement of dispossession of this property by the government, but there are equitable remedies like administrative remedies, government. This will also discourage the out-of-court settlement. Out-of-court settlement against court, like there are lok adalats you can approach to. Out-of-court settlements can happen through this as well. You can approach the secretary, you can approach the commissioner, these kind of remedies. So what you need to do if you want to file a suit against the government, you need to, under section 80 of CPC, give 2 months prior notice. Because if you see government actions, it involves a lot of filings, a lot of approvals. So there are a lot of bureaucratic processes are always involved, and it is serving the public purpose as well. So because of that, this exception is created that you cannot file the case against government under section 6 of SRA. This completes this part. Then you just understand, I've repetitively told you what is the purpose we have this section 6. It discourages people from taking law into in their own hand. What is requirement is there is always requirement of due process of law. Due process of law is the requirement. You need to follow the proper process if you want to dispossess a person from their property as well, to provide a summary or cheap remedy to a person unlawfully dispossessed. Because it's a quick remedy, it's a summary procedure which you need to follow. So let's understand the appeal procedure. Firstly, whatever has been a discussion till now, you understand one fact, that what is the purpose of section 6. Purpose of section I've repetitively used. It's like a quick remedy, like as specifically as I told you. So you see, this is a kind of a summary procedure. Summary procedure, if you see, like a quick procedure. You just go to court, you have been dispossessed from your property, you be like, court, this happened, and I was in possession, peaceful possession. No due process was followed. Certain kind of muscle power was used, as I given you the example कि मैं अच्छे से रह रहा था और किसी ने आके मेरे पोजेशन ख़राब कर दी, एंड कोर्ट ने क्या बोला, कोर्ट इज़ नॉट सीइंग इन टाइटल, कोर्ट इज़ लाइक follow the due process, till then this person who was in previous possession, उसी के पास possession रहेगा. ठीक है, that is the whole scenario. So under this, if any kind of whatever is decision of the court, no appeal or review process will be allowed. You will understand about appeal process, review process, revision process in your civil procedure code. But since CPC तो use ही नहीं हुआ, because procedure तो हमने use ही नहीं करा, CPC obviously will be used, because if any civil, you are approaching the civil, because section 6B, where will you enforce? Section 6 of SRA, you will go to a civil court only, no? Civil court only you will go, but the procedure of civil procedure is used, but the which act is involved? SRA is involved here. Alright, so since SRA is involved, you cannot use the review, revision and all, because these are CPC things. Under section 5 you can use it. This landmark case, what it said, this, but there can be scenario when this suit is wrongly considered as a suit under section 6. Then appeal is allowed. This appeal power is given to High Court under this section. The appellate court must remand the case for a fresh disposal. अगर कोई case, if it's not fulfilling the requirement of section 6, we have dealt with the requirement of section 6 earlier as well, whereby I told you these are the requirements. कोई case, it's not following all of these requirements, you cannot go to section 6, but judge erroneously thought that section 6 is involved, because judges are also humans, they can make mistake. If this kind of thing happens, section 6 is not involved, section 6 cannot be used, then the High Court is given the power. You can approach, you can file the appeal can be used, and this whole case can be rectified. Then section 6 cannot be used. As I told you, on what basis you can revise this? In this case, it was mentioned, Ghafoor Khan versus Amiruddin. This case was mentioned where there is an error in judgment is palpable, gross injustice and remedy is clear. Jurisdictional error, as I told you, jurisdictional errors in section 6 is not used. You cannot approach, then judgment cannot be disturbed even by the High Court. Then you can, then basically these are certain grounds on which a revision can be filed. Interim order under section 6 of SRA held not appealable under. Since I told you there is an process of interim order. You will deal with it also in your CPC. But interim order is like if SRE ka procedure is also followed under section 6. It's not required. It's not possible for court to every time give a proper decree. Sometimes an interim order is filed. Interim order is like injunction का order file कर दिया. In between interim is for the time being. For the time being, they have given this whole interim order. It is also not appealable because it is a summary procedure again. For suits under section limitation is not applicable. That also we have discussed earlier as well. No result from section 6 suit can be used against any party in a subsequent suit through normal procedure. Nothing in the result will impact the suit under normal procedure. What it means is that as we had dealt with the saving clause, this is very similar to saving clause what we had discussed in last class. If not watch the last class, please watch the last class. In saving clause, what we discussed is that SRA is a mechanism, and then there is a regular civil court mechanism, civil procedure under CPC. These two are different. If you go to court under SRA and the court declines you to give remedy under SRA, you have the opportunity. You can file the case under the normal civil procedure. This will not affect your remedy. You still have it. Not affected. This will not be affected. Then this case had talked about even settled possession of a trespasser must be protected. That is whole the essence of this section 6 itself is, because here even though trespasser don't have the title, but he was in possession. This possession should be protected. Even this trespasser cannot be dispossessed without the due procedure. Due procedure we dealt with. Nobody can use, कोई भी किसी को अलाउ नहीं कर सकते कि तुम फोर्स यूज़ करो किसी का पीसफुल पोजेशन लेने के लिए. हमें हमेशा प्रॉपर प्रोसीजर ऑफ कोर्ट रिक्वायर्ड टू बी फॉलोड. This is how for the immovable property we complete section 5 and 6 by this video. So I end this video here. In the next video we will be starting with our movable property from this example. This is a very interesting example. If you want to read before watching the lecture, I would recommend you to first read the section 7 and 8. You can interpret this whole picture. I will be using this picture to make you understand as an example. Thank you so much for watching this video. Please do subscribe and like. I have put in a lot of efforts to make this video. Please do subscribe and like the channel. Share it with your friends. Thank you so much. In case you have any query, you want to discuss something, you can please post on the comments. Thank you.